For the current meeting of the Interim Joint Committee on Judiciary, if you could please call the roll.
Senator Carroll, Senator Deneen, Senator Neal, Senator Nemus,
Present.
Senator Reed, Senator Stivers, Senator Thomas, Senator Wheeler, Representative Banta,
Present.
Representative Bauman, Representative Blanton, Representative Burke,
Here.
Representative Decker,
Present.
Representative Dietz, Representative Flannery, Representative Griffey, Representative Kulkarni, Representative Chris Lewis, Representative Derek Lewis, Representative Maddox, Representative Marzian, Representative Moser, Representative Nemus,
Here.
Representative Petrie,
Here.
Representative Roberts, Representative Stevenson, Representative Whitaker, Representative Williams, Representative Wilson, Co-Chair Storm,
Here.
Co-Chair Elliott.
I'm here.
We have a quorum. At this time, I would entertain a motion to approve the minutes from the July 24th, 25 meeting.
Motion.
We have a motion and a second. All in favor say aye.
Aye.
Any opposed? Those are approved. At this time, we would, I think Representative Flannery has an announcement.
Thank you, Mr. Chairman. I guess I want to let everyone know on the committee there is a lunch today sponsored by the Kentucky State Buildings and Trades Council discussing the formation of a blue-collar caucus. All are welcome to attend. It's in room 113.
Room 113.
125.
125. Thank you. With that, we'll go ahead and call the first presenters. It's the Kentucky Justice Reinvestment Initiative regarding domestic violence. I think they are online.
Hello, can you hear us?
We can. If you could, please identify yourselves for the record, and then you may proceed.
Wonderful. Thank you so much. My name is Ellen Whelan-Wiest. I am a Deputy Division Director at the Council of State Governments Justice Center. David, do you want to introduce yourself?
Good morning. My name is David Demora. I'm a Senior Advisor at the Council of State Governments Justice Center.
We are so grateful for the opportunity to present to you all today. Thank you for your patience as we do this virtually. We know it's not ideal, but we're thrilled to be able to bring to you all as a committee information and findings that we were part of gathering in Kentucky over the last couple of years, specifically related to domestic violence and the impacts and the prevalence of domestic violence across the state and specifically within Kentucky's criminal justice system and agencies. David, I think that you have control over the slides. Do you mind going to the next one for me? We'll just get this all set up. Our plan is to walk you through a portion of the findings that we had pulled together for Kentucky over the last couple of years. There's a lot more where this came from, but we realized we don't have that time with you all. So David will walk through the most important findings that we were able to pull together. But I just wanted to, if you don't mind going to the next two slides, David, just to give you a little background on this project before we share this information with you. Back in 2023, Kentucky leaders approached the Council of State Governments Justice Center, where we both work, and asked if we would be willing to use something called the justice reinvestment approach to understanding, like I said, the prevalence and impact of domestic violence. And really what justice reinvestment means is that we collect and analyze a tremendous amount of data, but we also work to talk to many, many people across the state where we're working to understand what the data is or may not be exactly telling us. David, do you mind going to the next slide for me? So this is just a timeline and a process slide to let you know that, again, it's been back since November of 2023 and then most of 2020 or all of 2024 really, that we analyzed a lot of data from across Kentucky agencies, zeroing in on domestic violence in particular, and also worked very hard to cover all of Kentucky that we could to speak with people with expertise and experience in these issues and these challenges so that we really could bring to you all information that felt like it was rooted in the reality of what folks in Kentucky are dealing with, and also hopefully some opportunities for exploring new ways of addressing domestic violence that might work better for victims and for the Commonwealth. So that's what I want. Oh, and let me just say there were many people involved in this effort, but I want to especially thank Senator Storm, Representative Burke, Representative Dietz, as three of the leaders and the partners who worked with us on this project over the last couple of years and really provided us with a lot of wisdom and guidance along the way. So thank you so much for all you did to contribute to our work here. And with that, I'll be quiet and I'll hand over the heart of the matter to David, who will walk you through what we found through this work.
Good morning again. I will do an overview of some of our findings over the next few minutes, and we'll leave some time for questions after that. In order for me to do this, I'm not able to see anyone. So Ellen, if you see any hand or anything that comes up, please let me know. The key challenges that we found in Kentucky is that, one, there's a high prevalence of domestic violence and victimization. And domestic violence is actually a major driver of the violent crime in Kentucky, and it contributes to the recidivism rates in Kentucky, and it consumes significant resources. And so we'll talk a bit about those. So first of all, there is a high prevalence of domestic violence and victimization in Kentucky. In Kentucky, half of all adults will experience contact sexual violence, physical violence, or stalking in their lifetimes. About 48% of women compared to 47% nationally, so about the same as we see nationally. Interestingly, a higher proportion of men, 52% compared to 44% nationally. Now, our analyses showed that an average of about 22,000 incidents of IPV, or interpersonal violence, occurred from 2018 to 2022. 60% of that was intimate partner violence, and 40% of that was child abuse or elder abuse and other types of family violence. Now, there's been an increase in recent years in the case filings and in the temporary protective orders, but the number of granted permanent orders has declined. We don't know why. That's simply a fact from the data that we were able to gather from the Administrative Office of the Courts. Now, charges involving violations of protective orders, on the other hand, have increased 43% since 2008. And the convictions for those violations of protective orders have increased 124% since 2008. One of the things that I have said in every visit to Kentucky and in every presentation is that Kentucky is honestly one of the leaders in the country in paying attention to this problem. While the problem is not solved here or anywhere, when I look at what Kentucky has done and the attention that it has paid and how it takes this seriously, it is genuinely one of the top 3 or 4 states in the country looking at this and paying attention to this issue. Now, a small number of victims of domestic violence receive compensation through the Office of Victims of Crime. Kentucky has indeed been increasing compensation payments to victims of domestic and family violence over the last now 6 years, 5 years when we did this. And as you can see, in terms of the type of offenses and the compensation claims, compensation in terms of assaults, in terms of homicides, and in terms of sex assaults. The majority of the payments tend to cover costs that are associated with the assault. Having said that, Kentucky does rank near the bottom among its surrounding states in the percent of victim compensation for DV-related claims. You can see here, Indiana is a bit lower, Kentucky at 3%, and then it increasing from right to left up to 28.3% in Virginia. Some of this just has to do with the complication in how people file or need to file. It's not Kentucky's unwillingness to do so, but there are just some barriers in the way that make it difficult for folks to file and get that compensation. So the key takeaway here is, while there is a high prevalence of domestic violence and victimization, The data indicates that Kentucky has a high prevalence of both domestic violence or family violence and IPV, interpersonal violence, and that there's significant room for improvement in how the Commonwealth supports and provides resources to victims. Secondly, DV is a major driver of the violent crime that occurs in Kentucky. Over a 6-year period, almost half of all of the person or violent crimes in Kentucky involve domestic violence. You can see here of the slightly over 228,000 crimes against persons during that period of time, little over 108,000 or 48% of them involved interpersonal violence or domestic violence. And victims of interpersonal violence are seen across all types of person offenses. For example, you can see it occurred in 22% of the homicides, in 42% of the sex crimes, 62% of kidnapping crimes, 21% of intimidation, 32% of aggravated assaults, and 59% of simple assaults. And so, particularly when you look at simple assault and kidnapping in Kentucky, more than half of the victims are reported to be intimate partners or other family members. Not surprisingly, I'm sure to folks, alcohol and or drugs were involved in at least a quarter of all the reported IPV incidents in the Commonwealth. To be clear, we suspect that it is higher than that. What we know from research is that when we look at the NIBRS numbers, that the incidents where alcohol or drugs are involved, there's typically significant underreporting. It would not surprise me if we were looking at close to double that amount in these types of crimes. Now, annually, the number of reported incidents and arrests for DV offenses in Kentucky has been increasing compared to 2016. You see fairly significant increases in the reporting, the number of incidents, from 18 or 19,000 up to 24 or 25,000. And you see a smaller but still increase in the number of arrests related to those offenses. So how are law enforcement officers prepared to respond to DV incidents? We surveyed law enforcement officers, and one of the very nice things is that 88% of them adopted model policies on how to respond to incidents of domestic violence. That's an excellent percentage. 97% received some guidance, and that guidance varied, meaning the amount of it, on how to interview and respond to victims. Again, both very impressive percentages. What is unfortunate is that at the time that we were there, most officers did not have screening tools to gauge whether the victims were at risk of serious injury. Only about 16% of them were using a screening tool at that time. I know that there has been work on and thinking about adding that, increasing that percentage of folks that are doing that. I do not know, because we have not been there in the last several months, where that has progressed to at this point. But again, a key takeaway here is that domestic violence is linked to nearly half of all violent crimes in Kentucky, with interpersonal violence driving a significant share of homicides and sex crimes. The issue continues to grow, with reported DV cases up and arrests rising annually, often compounded by drugs and alcohol, and again, likely a higher percentage than what we're able to see right now in the numbers. Excuse me. DV also contributes to recidivism. An analysis of a 2-year reincarceration trend showed that people with a history of civil protective orders recidivate at a slightly higher rate than people without such a history. You can see here overall about from 39% to 42%. So again, while that increase is slightly higher in terms of percentages, when we start looking at numbers, that can be very significant. And this is consistent throughout all of the years that we looked at. In 2022, more than a third, about 37% of folks admitted to DOC custody had prior DV-related civil protective order involvement. 33% of them had prior domestic violence-related civil protective order involvement as a defendant, and 7% as a plaintiff. Nearly a third of people on DOC supervision had been party to a civil DV case. It's a very significant percentage, 26% of them as a defendant and 11% as a plaintiff. Now, the misdemeanor population in Louisville that's supervised by DOC has a higher proportion of both civil and criminal DV history than people with felony convictions on DOC supervision. That's not surprising, as most domestic violence ends up in a misdemeanor setting. Now, the reason that we're showing you Louisville is that we were able to get numbers from Louisville because they contract with DOC to supervise these folks. That is not true in other parts of the state, so we were not able to do this kind of comparison across the state. We could only do it for this specific area. Law enforcement reported that repeat calls to the same address are a key issue in DV incidents. About 8% of people responsible for causing harm were reported in 2 or more incidents over the 5-year period. Targeting responses to those individuals could help reduce recidivism rates among the population. So, over a third of people entering Kentucky Department of Correction custody and nearly a third under supervision have DV-related histories. It is a major driver of what we see in terms of DOC population, both in terms of custody and supervision. And there's a small but impactful group of people who repeatedly commit domestic violence offenses, and that drives ongoing harm. It presents a key opportunity also for targeted interventions to break those cycles of violence. DV also consumes significant resources in the Commonwealth. In 2022, there were approximately 30,000 law enforcement responses to DV, requiring resources devoted not only to the initial responses, but also to any follow-up investigations. So there were over 39,000 DV calls in the first place. Resources, in other words, devoted to initial responses. And then there's the resources for follow-up investigations, almost 24,000 reported crimes. And then the resources used to work with prosecutors and the courts, about almost 9,500 arrests. So a lot of resources across a variety of parts of the system. When surveyed, officers reported that DV calls place a substantial demand on law enforcement resources, requiring significant time, personnel, and coordination. They indicated that they generally would send 2 officers to respond to an incident, which makes a lot of sense, of course, for safety. This created issues for the small offices that might have fewer than 3 officers on duty at any given time. 80% of the respondents indicated that the size of their staff was a major barrier hindering the agency from being able to effectively respond. They also reported that responses to domestic violence calls generally took at least an hour for the initial response. And of course, in addition, officers sometimes spent extended time on the scene to make sure that the victim was safe. After the initial call, of course, secondary investigations required additional time and resources. Between 2016 and 2022, there was a 10% increase in the number of case filings for permanent and temporary protective orders. So again, you can see this increase has been happening fairly consistently over the years. And domestic violence affects all regions of the state. It highlights a potential resource disparity where rural systems may be under-equipped despite high demand. When we look at these percentages, in Louisville Metro, a little over 41% of the cases involved DV. When we looked at other metropolitan areas, about 44%. The micropolitan areas, about 40%. And the rural areas, about 36%. So a fairly high number across all parts of the state. So DV is straining Kentucky's law enforcement and courts with 39,000 calls in 2022 and more protective order filings. Rural areas are hit especially hard with high demand, but they have fewer resources, making DV both a safety crisis and a big drain on system costs. But once again, I need to say that Kentucky needs to be proud that they are paying such attention to this issue and have been looking at this closely now for several years. We wanted to just give you an example of something that another state has done in terms of trying to deal with this problem. The High Point Police Department in North Carolina has managed to achieve substantial reductions in domestic violence reoffenses, so lowering of recidivism, by implementing targeted interventions for people who repeatedly commit domestic violence. First, the model has them identifying the people who are most likely to commit violent crimes, investigating carefully and prosecuting, pursuing criminal charges, notifying them that future crimes will be prosecuted to the fullest extent of the law, offering resources in the community to help people who commit DV change their lifestyles, following up with those people and their progress to ensure they're not committing further crimes, and then evaluating each case to determine if the individual was helped. So what have been the impacts of that model? So before and after looking at this, before the model, there were high rates of IPV-related homicides. 32% of their city homicides were IPV-related, or 17 IPV homicides over 5 years. After they implemented the model, they had 3 IPV-related homicides in 7 years. There was a significant police resource burden prior to the model. They were able to decrease the reoffending and the calls for service. Their domestic disturbance calls dropped 20% over 3 years. And they had limited success with the traditional methods. Despite high arrests and protective orders and prosecutions, the incidents continued to drive their violent crime rates. After the implementation of the model, they were able to have enhanced victim safety. Victim injuries and IPV-related arrests fell from 66.8% to 47.3%. So did they make it go away? No. Did they significantly increase public safety? Yes, very much so, as well as helping lower the number of resources that were being used for this problem. Now in Kentucky, you did an assessment in 2020. And these were some of the recommendations that came out of your assessment. 1, training and education. Institutionalize a training curriculum to address the topics identified throughout the report that you put out for judges, circuit court clerks, and the larger court community. Collaborate with the Department of Language Access at the AOC to assess gaps and priorities to provide meaningful language access for all Kentuckians accessing the court system. Collaborate with local law enforcement agencies to address barriers that prevent timely service of protective orders, especially in rural communities. Courts should partner with law enforcement and local victim service organizations to develop security strategies and protocols for cases involving domestic violence, interpersonal violence, sexual violence, and stalking. And the court system should partner with local batterer intervention providers and service providers to understand each other's roles and to implement a process for referrals and court-ordered participation. Reducing domestic violence incidents and DOC commitments by 25% would have large state impacts. In Kentucky, a 25% reduction of reported DV incidents would lower the number of victimizations by nearly 5,000 people per year. Additionally, an annual 25% reduction of DV reported incidents would lower the state's overall total person crimes by 12%. Reducing by 25% the number of admissions to the DOC for felony C and D, domestic violence offenses, would result in an average of 36 fewer commitments and avert approximately $2 million per year. Over a 5-year period, there would be over 180 fewer commitments and over $10 million in averted cost by reducing the recidivism. To give an example, estimated impacts that would be associated with reducing recidivism, if there was a 5% reduction, you'd have 48 fewer reconvictions, all the way up to a 25% reduction, you'd have 241 fewer reconvictions. And to be clear, when we say reconvictions, what we're talking about is lower recidivism, less domestic violence, less interpersonal violence, fewer victims, greater public safety. Now, these figures do represent an estimate of the potential impact, potentially through improvements to the batterers intervention courses that are being used in Kentucky. And by the way, Kentucky has indeed been working on improving those courses over the last couple of years and really looking at certifying them carefully and making sure the ones that are being used are effective ones. We do need to also note, though, that it's not known how many people who were reconvicted for a domestic violence offense within 2 years of a conviction had been ordered to participate in such a course, because the number of people that were required to complete a BIP course as a condition of their sentence was not available to us in the data that we received. You can find additional information, a lot more information, quite frankly, on the Kentucky Justice Reinvestment Initiative webpage that not only talks about what I have gone through, but really has a lot of other related information that we don't have time to go through this morning. And with that, thank you very much for letting us present this, and I will stop sharing my screen.
Thank you for your presentation. I have a couple questions, if I may. Do you all have any statistics regarding the prevalence of civil domestic violence petitions or cases, as well as companion criminal cases that may be affiliated with that case, assaults or strangulation type cases? Does that make sense?
I think you're asking, do we have any information related to specifically strangulation?
Well, the prevalence of domestic violence petitions in a civil setting and companion criminal charges that would be affiliated with that same case. Do you have any statistics on those?
Oh, I see. I would have to go back to our research staff to find that out if we have that specific relationship. I do not recall that, to be honest. I'm not sure that we do have it, that we were able to gather that from the data that we received, but we'll check with our research division to confirm that, and we'll let you know one way or the other.
Okay. Thank you. And then I just point out to the members, in 2024, we passed Senate Bill 319, which pertained to crime victims' compensation. And then last session, House Bill 38 made the third offense, domestic violence violation, a Class D felony. So thank you all for your good work here in the General Assembly. Any questions?
And again,
Oh,
I have to say thank you to Kentucky, for your focus on this, and your paying attention to this and what you've been doing in the last few years around this.
Thank you. Representative Burke.
Thank you, Chairman, and thank you so much to the presenters for your ongoing work on this. I want to thank my colleagues for the passage of House Bill 38, which I do think it will be a sea change moment for how we deal with reoffenses. I also want to thank, I see several advocates in the audience here today. Your work is what makes our successes possible, so I want to thank you for that. And then a question. Service of process is a major issue. I see that as I work in domestic violence court. I know that many of the survivors that I represent come back week after week after week to preserve their orders and hope that the offender has been served. And I know that tragically in Fayette County, we just had a mass shooting perpetrated by someone who had an unserved protective order against him. Perhaps if we could have reached him, we could have taken away the weapons that he used to kill 2 people in Lexington and wound others. Do you have any recommendations for how we can improve service of process when we know it's a struggle in large metropolitan areas, in addition to being a struggle in rural areas?
Every recommendation that I can think of requires resources, because the difficulty, and there's 2 difficulties, right? One is finding the person, but the larger issue is the time that it takes to do that. And so there are a number of jurisdictions that have dedicated units that's all that they do, but that works well in a large jurisdiction. That's much more difficult in a small jurisdiction where you only have a few officers available. And I don't have any brilliant or even semi-smart recommendations about what you can do when there's 3 officers available and that's all that there are. That is a sad and very difficult issue that is not their fault. But in large metropolitan areas in a number of parts of the country, they very specifically have developed, they have 1 to 3 officers that's what they do. That's all that they do. And that increases the success of service significantly by doing that. There's always the folks that they cannot find, of course, but the bigger issue really is the time that it takes to do that. You also mentioned something that I think is important, which is that when we look at the research, the overwhelming percentage of people who do commit mass shootings have a domestic violence history that wasn't their first event, their first violent event. And it's one of the reasons why it's so important to take this seriously.
Thank you so much, again, for the research and effort that you've put into helping us take a closer look at what we're doing well and where we have room for improvement. I appreciate your time and your suggestions. Thank you.
Thank you.
Representative Nemus.
Thank you, Mr. Chairman. I think this is a timely issue, given last night in Boone County we had 2 sheriff's deputies that were shot who were serving a warrant related to family. I think it looks like they're going to be fine. One of them was shot multiple times in the chest. I think the other one shot in the leg. But it looks like they're gonna survive. The shooter, I think, died of a self-inflicted wound. So I think this is obviously something on our mind continually, but certainly today as we pray for the full recovery of our friends in Boone County. I would also ask if I could. I wrote down a quote. I hope I have it right. I think you said Kentucky is one of the top 3 or 4 states that take domestic violence seriously. I want to ask you to elaborate on that and ask us why do you say that, and then also, so 2-part question, and then I'll give up the microphone. I don't need a follow up. Last time somebody from the domestic violence community came to us, I asked the question, what can we do? What one thing can we do to take this more seriously and so forth? And the request was what became House Bill 38, Representative James Allen Tipton's bill that we passed. So my first question is to elaborate on that comment, if I got that correctly. And then the second question is, again, now that we've done House Bill 38, what one thing would you suggest that we do to move the ball further in the right way? Thank you, Mr. Chairman.
Yes, you got my statement correct. And this is not to insult the rest of the states or to say that they are not paying any attention, but the amount of attention that Kentucky has paid, the bills that you have passed, the way that you do take it seriously, the impact that your victim services folks have had in the last several years in moving this forward, the seriousness with which the certification of BIP programming and looking for evidence-based programming that happens, the tracking of it, and the fact that you haven't just said, oh, well, it's something that happens. That is massively impressive that Kentucky has done that, and that you continue to pay attention and to move it forward. What's the one thing? I don't know that there's one thing, but I think the strongest thing that I would say off the top of my head would be to continue to increase the collaboration between the courts and law enforcement, and to ensure that the courts across the state do have the necessary education, knowledge, and resources to respond to these situations, because sometimes court systems can be overwhelmed with the volume. And I don't have the numbers for your system exactly, but I do know that depending on where we were in different parts of the state, in some places they had a lot of availability and they were responding very quickly, and in other places it was not happening, and it was sort of getting lumped in with everything else that the court was doing. And so I would really want to pay attention to making sure that whether that's family court or that's the other court part of the court system, that they are paying close attention and have the necessary resources, and that they are coordinating, or collaborating is probably a better word, closely with law enforcement in their area.
David, I also just want to highlight misdemeanor probation as an opportunity that we had found, and I'll ask if you can elaborate a little further on this. But David mentioned earlier that a lot of domestic violence cases, they don't usually jump to a felony. They end up in the misdemeanor category initially, sometimes repeatedly. And so there are a lot of people who are supervised on a misdemeanor status. But we found that in many parts of Kentucky, misdemeanor supervision, community supervision, is administered by private contractors. And the details of those contracts and the nature of that supervision and sort of what's involved is a little bit unknown or mysterious. And so the quality of that supervision is very hard to evaluate or understand what the impact is. And community supervision can be an area of great opportunity for intervention and behavior change and connection to treatment and programming. But in order to know that you're able to do that, you have to know what's happening on supervision. And I don't think we were able to understand that fully, partly because there's a network of private contractors who are administering misdemeanor supervision. So we were pretty clear, I think, and David, correct me here, but that addressing that and finding another way to supervise folks on a misdemeanor status for domestic violence specifically might offer a lot of opportunity for, again, behavior change earlier in a person's experience as a perpetrator of domestic violence.
Ellen's absolutely correct. What we know is that you need specialized supervision for domestic violence and for sexual violence. And while most places do have specialized supervision for sexual violence because they reach the level of felony so quickly, of course, you're not seeing that for domestic violence. And we were unable, as I mentioned in the presentation, to really gather any relevant data about what was happening in many parts of the state because DOC wasn't doing the supervision, and it was either local or private contractors, depending.
Representative Roberts.
Thank you, Mr. Chairman. And I have 2 lines of questioning, if that's okay.
That's fine.
Right. Thank you, Mr. Chairman. So first of all, I wanted to thank you for coming for this testimony. Family law, domestic violence law is one of those areas that I don't really specialize in. It's an extremely grueling process. So I just wanted to see, just for the educational side of things, I'm looking at the High Point Police Department model and the results that they have, but I want to look at step 1, and I just wanted to see if you had any cues in terms of what they look for whenever they're talking about identifying people. Like, what are the categories that they say make someone the most likely to commit these violent crimes? If you could elaborate on that.
Sure. What they do is they use screening tools. There are certain screening tools out there that tell you the potential for violence, something like the Domestic Violence Screening Instrument Revised, DVSIR, is one. Another one is called the ODARA. There's another one called the SARA. They all have acronyms, but there are several out there that have been validated in multiple jurisdictions, and officers can use them to make determinations. And some of the screening tools help make a determination of the immediate or short-term potential for violent behavior, and others have additional items in them to increase the ability to look for longer-term potential violence. To be clear, none of them are perfect, right? But they increase the ability to make a determination over professional or clinical judgment that isn't very good at best, not because we're bad, but because it's just very difficult to make that decision without looking at certain factors. So some tools have 5 or 6 or 7 factors. Some tools have up to 15. It allows them to better screen and make a determination. They don't get it right 100% of the time, but they get it right much more often. That allows them to lower the number of re-offenses by focusing on those individuals.
And what are those like longer term factors that they look into? Like what are the specific factors that they use to determine someone is more likely to commit this crime?
They will look at whether there's been any other type of criminal behavior of any sort. They will look at whether was the use of any kind of weapon, or a weapon was available at the time. Strangulation is an automatic one. Let me rephrase that. Attempted strangulation automatically is going to be looked at as an increase in risk. When there's been an attempted strangulation, the potential for a victim dying is dramatically higher. In other words, in another offense is dramatically higher. But those are three that I would mention off the top of my head again, whether or not there's any type of weapon either used or even threatened with, even if it wasn't used. In other words, maybe they might take out a knife, but they don't actually physically use the knife on the individual. Attempted strangulation, history of other criminal behavior, because how do I want to say this? So a lot of people that commit domestic violence, they're not criminal, right? There's a reason that it happened. Many of them, it's one and done. You do not see them again. There's a significant subset of individuals, particularly those who use weapons and things like strangulation, that they have generalized criminal thinking. That this is just one of a series of criminal behaviors that they're involved in. So if you are looking at an individual and you see that additional behavior, you're going to have an increased likelihood of future behavior from that individual in this area, as well as other areas. And so those are sort of quickly some things that I could say. We'd be happy to forward you a couple of examples of those different tools, and we'll send everything to Senator Storm, and he can give it to folks on the committee. But we're happy to send you a copy of the DVSIR, of the SARA, of the ODARA, just to give you an idea of what some of those items are and what they look like.
Right. Thank you. And for my second line of questioning, I wanted to go to I believe it's page 4 of your presentation. Just looking at the filing statistics here in Kentucky. So I'm just looking at the 2022 numbers. 72% of the cases filed do result in at least some sort of temporary relief in terms of an EPO. Can you just walk the committee through the distinctions in terms of the penalties for violating an EPO versus violating a DVO? I know the main difference is that an EPO is 14 days. It's ex parte. DVOs are up to 3 years, can be renewed. That's where evidence can be presented, cross-examination of witnesses. Just wanted to seek through the differences between the two in terms of how that really works on the ground.
I'm sorry, at what page?
Page 4.
What slide number?
It starts out slide number 8.
Thank you.
Sorry, small text.
I think you're asking me for some data about the differences in the responses.
Yeah, I'm just asking in terms of so my understanding, an EPO, that's ex parte. It lasts for 14 days. There are penalties for violating them, obviously, as well. But I just wanted to talk about like the logistics of what someone who is living under an EPO is dealing with in terms of the court system, dealings with law enforcement, compared to the same deal, except they have a DVO on them, which is the longer term one where there's cross-examination of witnesses, presentation of evidence. I just wanted to get into that one, which those seem to be far more rare as well.
The honest answer is that I don't have that information. That is not something that we were examining when we were there. We were simply or strictly looking at the filings and the protective orders. We weren't looking at then what the responses were by the court. That was not something we were asked to do. Okay. So I don't have that information.
That's okay. And I know you said you guys don't know why the number of EPOs are being granted are increasing while the number of DVOs are decreasing. Are you guys looking into that to try to find answers as to why there's that disparity that's growing?
We are not. And we are not because so two things. We didn't know because in the numbers, in the information that wasn't available. But the second thing is that our work in Kentucky has had to stop. The federal funding that was available for this work went away. And so we had to stop the work prior to us finishing what it is that we wanted to do, unfortunately. We wanted to come back to present what we were able to find before we had to stop. And that's why we're here today. But to be very honest, we're here today, for lack of a better way of putting this, we're here today on our own dime. We're not here today because the federal folks are continuing to fund the project. The project is over, and we had to stop sort of midstream.
Okay. Thank you, Mr. Chairman.
Thank you. Representative Dietz.
Thank you, Mr. Chair. My question is similar to Representative Burke's about service. And what I want to touch on is when I've talked to our sheriff's department, and I'm not techie, so maybe, and I want to see if you all found this, if there is a difference between the systems, the programs that the clerk's office is using and that the sheriff's office is using, and that there's somehow a breakdown in the communication and getting service. So not just the personnel being able to actually serve, but when you have the clerks entering that information and then getting the information to the sheriff's office, and then the sheriff getting that information before the court appearance on Monday or Tuesday. So that's my understanding of what's happening, at least maybe in my county and possibly in similar counties across the state. So I don't know when you all did this, if you saw that or if that was an issue that was raised basically, and maybe that goes to collaboration, but really maybe with the computer program systems they're each using?
Yes. Short answer is yes. The longer answer is, unfortunately, it's a common problem, not just in Kentucky, that across the country, people, most places are not using a system that they can all get into. And so each place is using their own system. Sometimes that system is a decade old and it does not talk to the other system. So they can't get to one another through that. So it gets in there, but then it's the people that still have to bring everything around to get from one department or one part of the system to another part of the system. There are some states that are now really looking at, and it's very expensive. I won't lie. It's very expensive, but there are some states that are looking at having a fully integrated system that includes not just the courts and law enforcement, but also includes their social services, Department of Mental Health, et cetera, so that the people have access to the appropriate information when these kinds of situations happen. Obviously, some of the information has to be firewalled, but there are a number of states, and they tend to be the smaller states, to be honest, that are really looking at developing or have developed integrated systems to deal with this. But your problem is very common.
Representative Marzian. Okay. Well, thank you for your presentation. Thank you for the questions today. A very robust conversation, and we look forward to working with you and David in the future, Ellen. Thank you all.
Thank you. We hope to have the opportunity. Appreciate you listening.
At this time, we'd invite our next presenters. Senator Thomas, if you could invite your group up to the table, and then once you get there, introduce yourself for the record. You may proceed.
Thank you, Chairman Storm and fellow members of the General Assembly. I am here today to talk about a problem we've had here in Kentucky for a number of years. We're a state that has been a hot spot with what's called heirs property, and that's property that's been passed on from generation to generation through the family without it being probated, and end up in a situation where you have a number of family members who own the property, but because of the number of family members, the property's not put to its highest and best use, and it becomes very cumbersome to sell that property, cumbersome and expensive. And when efforts are made to seek to consolidate the members, and that expense is taken, those family members who want to sell their property end up selling it at far less than the market value, at predatory prices that do not represent not only the fair market value of the property, but the legacy value of that property for the property having been in the family for a number of years. That problem needs to be corrected. And I have presented to you today a bill that I've filed several times and that I intend to file this year that would correct that problem so that we here in Kentucky could not only allow Kentuckians to receive the fair market value, a fair value for their interest in that land, but at the same time put that property to its best and maximum use here in this state. And that's the Uniform Partition of Heirs Property Act, and that's been promoted by the Uniform Commission of Laws. And with that brief introduction, I'm going to turn it over to Mr. John McGarvey to talk about how the Uniform Commission of Laws intends to or has intended to correct this problem and prevent these kind of predatory practices, and again allow this property to be sold at its highest value, its fair market value, for the benefit of those landowners.
Good morning, Mr. Chairman. I am John McGarvey. I come to you not as an advocate for any party, but as your Uniform Law Commissioner.
Is your microphone on?
I think it is.
Okay, just pull it closer a little bit.
Pull it closer. I've
Thank
never
you.
been accused of not being loud enough. I'll say it again. Good morning, Mr. Chairman. I come to you not as an advocate for any party, but as your Uniform Law Commissioner and Legislative Liaison for the state of Kentucky. I have to say good morning to my representative also, Mr. Nemus, who represents my district. Uniform Law Commission's slogan is making a more perfect union through better state laws. It's the most nonpartisan group I have ever worked with. At this year's annual meeting, I got to sit next to our newest commissioner, Lawrence Van Meter, our immediately retired Chief Justice. It's good lawyers trying to put together good legislation. The Uniform Partition of Heirs Property Act is good law. It's good for Kentucky families. It's been endorsed by the American Bar Association section of real property, the American Bar Association section of trust and estate law, the AARP, and the Farm Bureau. I am not a real property expert. As my wife would say, I'm a certified Uniform Commercial Code nerd. Hence, I have with me this morning Jane Starnecki from the Uniform Law Commission's Legislative Council. She considers this so important, she flew here last night from Seattle, and I'll turn this over to Jane.
Thank you so much. Can you hear me okay? Thank you so much, Senators, Representatives. I really appreciate your taking the time to learn about this very important issue of heirs property. So this is just a brief PowerPoint overview, only 8 more slides. I promise I will keep it short. So the Uniform Partition of Heirs Property Act was drafted by the Uniform Law Commission and finalized in 2009 after a 3-year period of study and drafting on the issue. That drafting committee was made up of ULC commissioners, an American Bar Association advisor, and many experts from throughout the title and real property industries who gave us their input and thoughts. It has been enacted in 26 states and territories. I'm going to show you the map of all of the states where it has been enacted. So those green states are states where the act was introduced in this past legislative session in 2025. Pennsylvania, knock on wood, we're hoping will be enacted in the next couple of months here. We've already cleared that bill through the Senate or through the House, and we're waiting on Senate approval. And of course, Kentucky is green here as well because Senator Thomas introduced it in 2025 here. So the Uniform Partition of Heirs Property Act is aiming to prevent predatory partition actions from happening. And the way that can happen is that when owners of real property inherit a piece of property from a family member, and that family member dies with either no estate plan at all or with a very simple estate plan that has those heirs own as tenants in common, they're very vulnerable. Tenants in common, instead of owning separate acres of the property or separate parcels of a larger parcel, will instead own a small percentage of every single square inch of that property. So it makes it very difficult for them to do day-to-day maintenance on the property. And under the underlying common law, all of the tenants in common have to agree in order to sell the property. However, one tenant in common can sell their share to anyone they want. And that will remain true under the UPHPA. That's still true in states that have enacted the UPHPA. But The mischief that we're trying to prevent here is a forced sale of heirs property. So if one tenant in common sells their share to an outside individual, for example, a property developer who wishes to get the entire property for cheap, that outside individual can file a partition action currently under Kentucky law. And that often results in the property being sold on the courthouse steps for pennies on the dollar. So not only are these families deprived of their ancestral homes, they're also given a small fraction of the generational wealth that that land should carry. So under the UPHPA, we create a series of due process protections that are aimed at, first, keeping heirs within their home and on the property whenever that's possible, and second, when that isn't possible, making sure that they get the fair market value for their land so that they're not also stripped of the generational wealth. When the land cannot be kept within the family, those sale provisions are designed to mimic a sale between a willing seller and a willing buyer instead of that forced sale on the courthouse steps, often at auction and often only for cash. So there's no ability to secure financing. So there are 5 due process protections. I'm going to briefly go into every single one. So Section 4 of the UPHPA discussed enhanced notice, which includes notice by posting at the property. Often these sales are sort of happening under cover of night, but requiring a sign at the property that's being affected will hopefully get the word out into the community that this property is the subject of a partition action. Second, the act requires an independent appraisal or an agreement by the heirs to the property's value if they don't want to pay for an appraisal. We recognize that they can be quite expensive, and sometimes the heirs have had a recent appraisal. But that appraisal value will be used throughout the process to determine what the fair market value is, and when we determine the price of a share, that appraisal amount will hold. Third, the Act gives an opportunity for the co-tenants who are responding to buy out the share of the individual who filed for partition. So the way that works is, let's say Senator Thomas, Mr. McGarvey, and I are all cousins, and we have a share of we each have a third of our property. If I file for partition, the two of them can decide to buy out my share at this point. There's time for them to secure financing. And if that happens, if they decide to buy out my share, then they keep the property. The property is reapportioned amongst the two of them, and the action is closed, so it will not go any further. This is a really straightforward, nice, clean way to keep land within the family. If the two of them do not want to buy out my share or do not have the financial means to do so, then we will proceed to the next 2 steps. So the 4th due process protection is specific factors that the court has to consider before determining whether the land can be physically divided. I'll go back to our hypothetical with the 3 of us sitting up here. If we all own a single family home, there's likely no way that that single family home can be equitably divided so we all have a piece. But if we all own a large piece of undeveloped land or a large piece of farmland, that under certain circumstances probably can be physically divided. So the court at this step must determine if that property can be physically divided. And if it can be, that's exactly what they'll do. So I'll get my third, each of them will get their third, and we'll be able to do whatever we want with it going on from there. In the example of a single family home, or for example, a parcel of property that's been improved by a home where it cannot be divided, we can't find a way to separate out the acres, then the property will be sold. But again, that sale will mimic a sale between a willing seller and a willing buyer. It will not be a sale on the open. It will be a sale on the open market. It will not be on the courthouse steps. The intent here is both to make sure that the families receive their fair market value, but also to act as what we call shark repellent. So we want to make this look unappealing for property developers who are trying to get a small piece of it and acquire the whole parcel for cheap. So by requiring the whole parcel to be sold for fair market value, we're hopefully closing off that pipeline of folks who are buying off the one share with the intent to get the whole thing. The last thing I want to note is that there are additional farm bill benefits from the 2018 Farm Bill for states that have enacted the UPHPA. So those include authorizing a loan program for heirs property owners that allows them to begin the process of clearing title. Often title is very unclear for families that have had their land passed down through the generations. It can be quite an arduous process to figure out who owns what piece. And so the USDA Farm Bill authorizes this loan program and gives priority to farmers in states that have enacted the UPHPA. Once a farmer in a UPHPA state has begun the process of clearing title, then they are eligible for a farm number. And that farm number makes them eligible for disaster assistance, other programs administered by the USDA. Those farm numbers can be very difficult for farmers to get under the current scheme. And so this helps them do that to avoid land waste and helps property owners avoid those predatory partition actions. So that's it for my presentation. I think we can go on, Senator.
Yeah.
Well, let me make one point. I don't know how close attention you all paid to the map that Mr. Necky presented. This is not a red-blue issue. It is now the law of Arkansas, Mississippi, Alabama, Georgia, South Carolina, and Florida. So it's a totally nonpartisan bill.
Let me go ahead and get Senator Wheeler. He had a question real quick.
Thank you, Mr. Chair. Just a couple brief ones. So, under the current scheme, and I've not done a ton of real estate, but I guess I've done enough to be dangerous, as they like to say. When the sale occurs, they do go ahead and appoint appraisers anyway, and to determine the value of the property. Now, obviously, the property does not have to bring that value at the auction, but if it doesn't bring, is it what, 2/3 of the appraised value? Do not the heirs under the current system have a right of redemption to gain the property back?
That's correct, Senator.
Would this essentially eliminate that?
Yes, it would. The problem is that you don't have these heirs who are, for lack of the better word, do not have a market, Senator Wheeler, from wanting to come back and receive a right of redemption. They own like maybe one 1/100ths or 1/8, and all they're interested in doing, because that 1/8 interest has no value to them, is to sell the property and move on. And so therefore they're willing to take less than what might otherwise be a fair market value just to receive some money from the property. That's harmful from the standpoint is that it doesn't give them the true value of the property, and more importantly, encourages this continued practice of predatory action by those individuals who just acquire a brief amount and then allow the property to go through auction through a master commissioner sale.
Okay, and I guess secondly, and if it's in the bill, and I apologize if I missed it. I mean, how long would the property remain on the market before, I guess some issue with the master commissioner sale? It's definitely not a perfect process, and there's a lot about this bill that I like, but it is a rather fast and efficient process. I mean, it gets it through fairly quickly. How long would would it be up to the court as far as the length of time to get a sale at fair market value, or is there a specific timeline in the bill that I may have overlooked?
There's a timeline. I'm going to let Mr.
Thank
Necky
you.
answer that.
Thank you for that question, Senator. I'm looking for the timeline right now, but one thing I do want to point out is that the efficiency of the current system, thank you, the efficiency of the current system is not necessarily a good thing for heirs property owners. So just because the property is sold quickly at auction, that often means that they're foreclosing upon an opportunity to either buy it themselves or sort something else out. I think that page that you showed me was about notice, but
like I said, I may have missed it.
I think generally it's listed for I want to say it's either 30 or 45 days on the open market.
Okay.
And if it cannot be sold on the open market, then there are other alternatives. So sometimes an open market sale just is not going to be appropriate. So the court can order alternatives, but an open market sale is the default.
Is one of the alternatives a commissioner's sale?
Yes. So the court can appoint commissioners as well to administer.
Okay. I mean, my only concern would be if they drag it out for over a year or something, we may want to put some type of time limit on that. And I guess finally, what about like a bank? Will this affect foreclosure actions in any way at all, in the sense if money's owed on the property by a bank?
Well, keep in mind, we're not talking about a foreclosure action here. We're talking about an action where.
Well, I think you could have both. I think you could have heirs own an interest in the property that has money that's still owed on it.
If it would affect foreclosure, Senator, I would suggest to you that John Cooper would be here this morning.
I suspect he would be too. So, but I just
and I might not be.
Yeah, well, I kind of figured as much, but for the very reason that you mentioned. But so this would basically be unencumbered heirship property.
One of the things you bring up about time frames is these are uniform laws. They are not exact carbon copy laws. And to the extent that this committee or this legislature wanted to adjust the time frame, that's easily done.
Good deal. Thank you. Thank you, Mr. Chair.
And I'm sorry, Senator, just to close the loop on that, it does just say a reasonable amount of time. So that we would potentially be open to making that a set timeline just to make sure that people have enough time and they're protected.
And Senator, I can't emphasize this point enough. The design of this bill is to make sure that when the property is sold, it's sold at its reasonable and fair market value.
I agree, Senator Thomas. Like, there's a lot about this bill, but I guess what we don't want is for it to sit out there 2 or 3 years. And that's the point I was making.
Representative Blanton.
Thank you, Mr. Chairman. I have a question. When you were going through your slides, next to the last slide, number 4, it says specific factors the court must consider in determining whether the land can be physically partitioned. And then in parentheses, you have partition in kind. Mm-hmm. Now, if they're dividing the properties up, when we're talking about partition it in kind, is that based on equal acres, equal value? Because the region I come from, you take 100 acres and you might only have 10 or 15 flat. The rest of it's pure mountain hillside.
Right.
That 10 or 15 acres flat is going to be worth a whole lot more than that mountainside. So how is that? What does that encompass?
Thank you for that question, Representative. It would be the value. So we do fully recognize that not all acres are created equal. Not all parcels are created equal. So the court would be within its discretion dividing up the property. So maybe someone gets a couple acres of mountain, right? And someone else gets several more acres of undeveloped land. That would be the intent of the court when it does the partition in kind.
Very good. Thank you. Thank you, Mr. Chairman.
Representative Flannery.
So comment and then a question, please. I guess my comment would be on the due process protections. I really don't see how this is much different than the current status of the law, because if there isn't an agreement between often the siblings that have inherited this property, and I've heard some of my lawyer friends call probate cases sibling divorces. If they're not in agreement, there's going to be a partition action filed. Oftentimes, a judge cannot equitably divide or partition the property based upon the characteristics, as Representative Blanton described, the certain topography, geography of the property. So really the court's only option is for a master commissioner cell, which I guess is my question. This proposal, I guess if you distill this down, tries to eliminate a master commissioner cell and substitute a private auction or cell. And it's been, I guess, put forth that that's going to bring a higher value of the property. Oftentimes these master commissioner cells, just depending on maybe the date and time of the sale, sometimes very few people show up to bid. Maybe if it's a week before Christmas or bad weather, folks don't show up at the courthouse steps and you do have a property that sells for less than maybe it would on another date, time, location. I guess my question is why would this bring more money if it's a private sale than a master commissioner sale?
Let me easily address that, Representative Flannery. And again, I can't overstate this enough. Under the current master commissioner sale, where you don't have a property that's being subject to a mortgage, the heirs have just decided that we all want out and that we want to sell the property, then while there is a value that the master commissioner may set, he or she is not bound by that value. And so while the property may have a projected, let's say, fair market value of $100,000, if the master commissioner can only get $25,000 from that, then that sale goes. And again, unless, as Representative Nemus came back, the family decides, or someone comes back and says, well, we want to opt out after a period of time, then that goes. If you look at section, I want to point you to section 6. That's on page 3 of the bill. Okay, there's a very clear delineated section that talks about setting forth a valuation, and that valuation is subject to a hearing and an order by the court. And what this bill does is make sure that whatever this property is going to be sold for, that is a court-ordered valuation after having gone through a due process hearing, so that to ensure that there's no predatory pricing or no undervaluation of the property. That's the biggest difference here than what you traditionally think about, or what happens under the current system that we have here in Kentucky.
Representative Flannery, I'm not a real estate lawyer, but I am somewhat familiar with the foreclosure process. Generally, in the foreclosure sales I have attended, it's the same group of bidders there almost every time. There's always that fear there may have been some decisions made away from the courthouse on who is going to get that piece of property. This eliminates all of that. It exposes it to a much larger market to obtain a fair market price for the property.
And Representative, I do want to go to something that you mentioned earlier. I think it's important to note that there certainly are cases where the outcome may end up being somewhat similar to the way it is under current Kentucky law if we do enact this act. However, for the cases where things would have gone really sideways, right, and people would have been kicked off their land, deprived of its generational value, that's where this act is really going to offer the most protection. I also want to point out that if all of the co-tenants agree to sell the property, this act will not apply. So all of the co-tenants can agree to sell it to whomever they want. This is really for those scenarios where there's someone who wants out, the rest want to stay. They don't want to get kicked off of their land. They want to keep the value. And I think that's not necessarily an edge case, but there certainly are circumstances under which the outcome may be somewhat similar.
If I could have a follow-up, please. So, Senator Thomas, if we think we are substituting the redemption rate somewhat with this private seller auction, and I can understand the purpose of that, because depending, as I said earlier, who shows up, it may bring low dollar, but what guarantees that your fixed or basement amount pricing will be met at a private seller auction? And if it is not, what happens after that?
Let me ask you a question this way. We've already gone through, under this act, we've already gone through a hearing process in which the court has said this is the fair market valuation of the property. So we've already established that. Now, if after that has done, there's no one who comes forward and says that I want to buy this property at a fair market valuation, then we can go back to the court and look at other alternatives, such as going to the master commissioner's sale to try to sell this property. But we only get to that last point, Representative Flannery, after we've gone through all the other steps to try to guarantee that the property is sold at the fair market valuation. The master commissioner's sale, as your question posits, is the last act of resort, not the first act of resort, and that's the big difference in this statute.
And Representative, that's section 10B4. It lays out the alternatives. I'm sorry, 10.4. Section 10, subsection 4, A, B, and C. So the first option is to, if there is no offer at fair market value, after a reasonable amount of time and after the court holds a hearing, the court can A, approve the highest outstanding offer, if any, B, redetermine the value of the property and order that the property continue to be offered for an additional time, or C, order that the property be sold by sealed bids or at an auction.
Last comment.
Well, Mr. Chair, we do have a lot of advocates for this bill. The Kentucky Association of Retired Persons has come down today. They are a strong advocate for this bill. I'd like them to come forward and have a minute or two to talk about their reasons and justifications why they think the General Assembly needs to pass this bill.
That's fine. Please come to the table and identify yourself for the record.
Good morning. Can you hear me?
Go ahead, Darrell.
Good morning. Co-chairs, Senator Storm and Representative Elliott, and the honorable members of the Interim Joint Committee on Judiciary. My name is Darrell Baker. I'm a volunteer serving on the AARP Kentucky Executive Council. Today, on behalf of the 424,000 Kentucky members, I am testifying in favor of the proposed housing provisions addressing the legal and economic challenges tied to heirs property, land inherited without a will, often resulting in unclear ownership and vulnerability to forced sales. AARP is the nation's largest nonprofit, nonpartisan organization dedicated to empowering people 50 and older to choose how they live as they age. For nearly 67 years, AARP has been committed to making all our communities great places to live. This includes having access to safe, affordable, and accessible housing. Briefly, heirs property refers to land passed down without a will, resulting in shared ownership among descendants. This often leads to legal and financial challenges. Kentucky ranks high among southern and Appalachian states in their heirs property prevalence. Lack of clear title, risk of forced partition sales, ineligibility for federal aid. During the interim, we urge the committee to consider these options to deliver legislative supports and solutions to Kentuckians. Adopt the Unified Partition of Heirs Property Act. The Unified Partition of Heirs Property Act ensures fair market value in forced sales and simplifies ownership claims. As of early 2024, the Uniform Partition Heirs Property Act has been enacted, as said earlier, in 26 states and territories. Adopting legislation of this type can better protect families from losing inherited property through forced partition sales, especially in cases where land is passed on without a will. Addressing heirs' property issues now is essential for preserving generational wealth, stabilizing communities, and ensuring equitable access to resources. Legislative action can provide immediate relief while long-term reforms are developed. Thank you for the opportunity to testify today. And if you have any questions or need any more information from us, please contact Daniel Rowe, State Advocacy and Community Engagement Manager of AARP Kentucky. Now I pass it back to Senator Thomas.
1 second. So, members, in your material after this meeting, we'll have the letter from AARP uploaded. We didn't get that in time to upload it. And then we have a question from Representative Nemus.
Thank you, Mr. Chairman. I'll be quick. I know it's close to the end of the meeting. I'll say it first that I want to say hello to my constituent, John McGarvey. In my neck of the woods, our congressman is known as John's boy. So that's good. I will say that thank you for bringing this bill, Senator. I think it's a very good bill. I would mention two things to the committee members looking at this. If you're going to sell your house, you're not going to put it up for auction. You're going to put it on the market. So we know that's the right way. That we know that's the way it's normally done. I would also say, especially to our non-lawyers, our interstate succession laws. That's the laws that we have in place when someone doesn't have a will. And the design of interstate succession is to be as close as possible as what we think would have happened had that person had a will. Nobody in their will, when they have a will, no executor puts it up for auction at first. They put it on the market. Auction only if the market doesn't bring the right price. All this does is it's in keeping with what interstate succession laws are supposed to be, and that is to mirror what we think the decedent would have done if she would have had a will. This is a great bill. I'm 100% behind it. Thank you for bringing it.
Yeah. Thank you for saying that, Representative Nemes. I really, really appreciate that. And let me close by pointing out to you one other unique aspect about this bill that we don't see very often here in Kentucky regarding legislation, but applies here. Okay. Most time we just pass legislation and we say, okay, this it's good for Kentucky. We did what's right for Kentucky. We applaud ourselves. Under this bill comes with benefits from the federal government. The 2018 U.S. Farm Bill does a couple of things. One, it says for those states, and you've seen the list, that adopt the UPHP Act, they receive both a farm lot number. They receive any additional benefits that might be might be occurring if there's some kind of damage or harm, weather-related harm to that farmland. And if they want to get a farm loan, they can receive special benefits from having loan access to help build and expand that farm. So when we pass this bill, we get benefits that we otherwise do not have now, for our farmland, our agricultural land. And I want to just add to something Representative Nima said. Okay.
Yeah, don't demote me to the senator.
No, I remember that. We think about this as an agricultural problem, and and it's designed to address obviously farmland. But I can tell you, living in the city of Lexington, that we have heir property issues in urban communities too. Land that's been passed on or property that's been passed on, for generations there. That you have families now owning, these properties that are owned by 30, 40, 50 heirs. So this is not just unique to rural Kentucky. It also applies to urban Kentucky as well.
Last question to Co-Chair Elliott.
Thank you, Mr. Chairman. Thank you, Senator, for presenting this. I was listening to a podcast not long ago about this issue, and it has this hasn't been said today, but I think that there has been a disproportionate impact among minority communities that this would help very much, and so I recognize that today. As co-chairman of this committee, with all of the discussion about auctions and prices and so forth, there's typically a way to set a reserve price, and I don't know if the court could do that with this proposed legislation, but there may be a way to do that if there is some concern about a private auction not yielding the value of the property, that you could set a reserve bid price, and then if it didn't bring that, could go back. So I think that would be, another potential safeguard that we could put into this. My question goes to the title issue. I know that you had, in your presentation, ma'am, had mentioned money for title research or something to that effect. So I guess there's a fund that would be set up that would try to improve, our system here in Kentucky. And I guess, are we satisfied if we go through this process that the title is clear? Because really that's what we're looking at here, is making sure that title of the property is ultimately cleared up so that it is marketable.
Yes, thank you for that question, Representative. So yes, the title clearing process you're talking about is from that 2018 Farm Bill. It authorizes financial institutions in states that have enacted the UPHPA to offer loans that are specifically for the process of clearing title. From a title perspective, I would like to add that the American Land Title Association has endorsed this act, so they understand the value of it from both a title preservation standpoint and from the standpoint of ensuring that people are able to keep their property for many generations going forward.
Thank you for your presentation. Members, I see nothing else on the agenda. I would entertain a motion to adjourn. Got a motion second. All in favor say aye. We're adjourned. Members, take note that the next meeting is going to be September 18th. That's only 2 weeks away, September 18th at 11 o'clock.